All right, so we'll commence and convene this board equalization meeting. And David Lillard, Tennessee State Treasurer and Vice Chair of the board. Robin, you want to call the roll, please? We have members that are virtual, I believe.
Yes, we do have 2 members joining virtually. So we'll start with our virtual members, Miss Betty Burchett.
Here.
And Mr. Jeff Fleming.
Here.
Thank you. All right, and then in person, we've got Secretary Hargett, Commissioner Jaragano, Miss Erin Merrick.
Here.
Comptroller Mumpower, absent, and Treasurer Lillard.
Here. All right, Chair declares we have a quorum present. First order is public comment. Mr. Robin, Mr. Pope, do we have any public comment for the board?
I did not receive any requests to make public comment for this meeting. You do have several requests to present oral argument related to our final agenda item, the petitions for review. You can hear those oral argument now or you can hear them during the agenda item if you prefer.
I start with the board. We'll just take them up when we take up the particular item, I assume is what we do.
That's typically what we've done.
All right. Okay. All right. So the next item then beyond public comment is item number 3, review of the minutes for October 20, 2025. Is there a motion with respect to the minutes? I'll second that. So there's a motion and second to approve. Any discussion? Seeing none, Mr. Pope, call the roll on the motion to approve.
Again, we'll do our online participants. I got Miss Betty Burchett,
Yes.
Mr. Jeff Fleming,
Yes.
Secretary Hargett,
Yes.
Commissioner Jaragano, Miss Erin Merrick,
Yes.
Comptroller is absent still, and then Treasurer Lillard. Oh,
Aye.
sorry.
You want to
Gotta
vote
look
on
up
that
my
one,
paper.
Comptroller? The minutes for October
Yes.
20, 2025. Okay. All right. He votes aye. All right. So the ayes have it and the matter is adopted. Item number 4 is our next item, review and approval of assessment designations. Mr. Pope.
Yes, I originally believe we had DPA. These are our training people who have accomplished the training requirements for Tennessee Certified Assessor and Tennessee Master Assessor listed in your agenda summary.
Okay, is there any discussion on these items?
Move approval.
All right. We have a second?
Second.
A second. All right. Any discussion? Seeing none, Mr. Pope, call the roll on the motion to approve.
Miss Betty Burchett,
Yes.
Mr. Jeff Fleming,
Yes.
Secretary Hargett,
Yes.
Commissioner Jaragano, Miss Erin Merrick,
Yes.
Comptroller,
Yes.
Treasurer Lillard.
Yes. All right. So the item is unanimous and it is approved. Next item is item 5, review and approval of the report of personal property compliance in your agenda. Let's see who is going to present this. Ms. Bauer.
We had Mr. Macy Brower.
Okay.
Yep,
Mr.
coming
Bauer.
up to the table, and then green means go.
Mr. Chairman, members of the board, thank you for the time today. Pleased to inform the board that DPA has reviewed the 2026 tangible personal property plans, audit plans for all 95 counties. Those plans are all complete and accurate. We have them all on file for review. Your memo there has a summary of all 95 plans DPA is submitting for your approval.
Okay. I'll move to approve. Is there a second?
Second.
Second. Any discussion? Seeing none, Mr. Pope, call the roll on the motion to approve.
Miss Betty Burchett,
Yes.
Mr. Jeff Fleming,
Yes.
Secretary Hargett,
Yes.
Commissioner Jaragano,
Yes.
Miss Erin Merrick,
Yes.
Comptroller,
Yes.
Treasurer Lillard.
Yes. All right, the item is unanimous and it's approved. Next item is review and approval of the 2025 tax aggregate report. Mr. Pope, are you presenting this?
Yes, this tax aggregate report includes, as the name implies, aggregate information about property assessments across the state for the tax year 2025. This report is done on my behalf from the Division of Property Assessments, who actually assembles and compiles this report. They've included it. It's in a kind of heftier package before you for review and approval by the board.
Okay, the only request the chair has about this is that we produce a copy of the report that you can easily read all the numbers on it. They're kind of light. It's hard to read. I've tried to get one that was better, but couldn't get my hands on it. So I've looked at it, but any discussion on this item? All right, seeing none, Chair would move to approve the tax aggregate report as proposed.
Second.
All right, we have a second. Any discussion? Seeing none, Mr. Pope, call the roll on the motion.
Yep. Miss Betty Burchett,
Yes.
Mr. Jeff Fleming,
Yes.
Secretary Hargett,
Yes.
Commissioner Jerrica,
Yes.
Miss Erin Merrick,
yes,
Comptroller Mumpower,
Yes.
Treasurer Willard.
Yes. All right, unanimous. That item's approved. Go to item number 7, review and approval of resolution certifying the 2026 appraisal ratios and review of current value updates. There are materials in your packet on this. Any discussion on this item? Seeing none, is there a motion to approve this item?
So moved.
All right, we have a motion. Is there a second?
Second.
All right, we have a second. Seeing no discussion, Mr. Pope, call the roll on the motion to approve.
Miss Betty Burchett,
Yes.
Mr. Jeff Fleming,
Yes.
Secretary Hargett,
Yes.
Commissioner Jerrica,
Yes.
Miss Erin Merrick,
yes,
Comptroller Mumpower,
Yes.
Treasurer Willard.
Yes. All right, number 7, that item is approved. Agenda item number 8, review of Rutherford County non-compliance completion, information purposes.
Correct. There's no action item. This is for informational purposes only.
Are there any questions or discussion about this item? All right, seeing none.
I'm sorry, Mr. Chairman.
Mhm.
Do we have a report? Are you going to report on it, Brian?
Okay, I read the memo. It's in the packet, so.
Mr. Chairman, I would just thank this board for the action it took. What we found in Rutherford County was extraordinarily concerning for the taxpayers of Rutherford County. And so I think it was important that we did what we did. I wish I could say that I didn't think we might be back in this situation in the not too distant future, but can't say that today.
Well, I noted from the memo that was in the packet that we had thousands of adjustments made as a result of your review. So,
There are, in just the sample that we reviewed,
all right.
that is correct. There are thousands of Rutherford County taxpayers who are receiving either a refund or an additional assessment. And so things can only get better.
Okay, anything further on that? Seeing none, we'll move to item number 9, which is review and approval of reappraisal plans and programs, which is an action item for the board. Is Mr. Brower going to present that or? Okay.
DPA has received and completed its review of 24 of the 28 counties completing revaluation for 2026. 4 counties at the time of submission have not obtained local approval for their reappraisal plans. Wanted to also highlight, also listed below for your approval are 5 amended reappraisal plans in red font. You'll see there that Roane, Anderson, and Hamlin counties all reappraised in 2025, and they're now requesting an amendment to add indexing to their existing plans. McMinn and O'Brien were last reappraised in 2023 and are now requesting to move from a 5-year reappraisal cycle to a 4-year reappraisal cycle with a revaluation now in the 2027 tax year. And also wanted to highlight that any county you see there with an asterisk is electing to index. We have 3 in 2027 and 14 in 2028. DPA is presenting the plans for your approval.
Okay, any discussion on this item? All right.
Motion to approve.
Approve. All right.
Second.
Second by
I have a
Commissioner
question.
Giardino. Yes, sir, Comptroller.
Thank you very much, Macy. You said 24 of the 28 counties moving into this reappraisal cycle have provided a plan for review and approval. Who are the 4 counties that are on the precipice of the need to get this work done, but have not presented their plan.
Yes, sir. The 4 counties that do not yet have local approval are Coffee, Hawkins, Rutherford, and Tipton.
Coffee, Hawkins, Rutherford, and Tipton.
Yes, sir.
Would it be appropriate, do you think, to send a letter to the assessor copying the mayor and commissioners of these counties?
I believe
That,
it would.
I mean, we're not scheduled to meet again as a board to approve these reappraisal plans until August.
That
I
is
mean,
correct.
that's the next scheduled meeting of this board. And that's vital time between now and then. I mean, here we are with Rutherford again, which is concerning in and of itself.
Well, Comptroller, let me ask, could we ask the staff if they have had conversations with these counties and what the counties are saying about their status?
What, Macy, are you familiar with that?
Yes, sir. I can speak on that. Coffee County, in speaking with the assessor, had some sort of mix-up. The assessor was on the docket for the commission meeting in March and had some sort of mix-up with the mayor. Was supposed to be on the docket, ended up, wasn't on the docket, and it didn't get amended. So as I understand it, the assessor has that on the docket for the April meeting, which is tomorrow night. So they weren't in time. Hawkins actually submitted an approved and signed plan on Friday of this week past, but passed the deadline for this packet. Tipton, it's a mix. The assessor there has had some health issues along with the commission and the assessor not being able to agree on what they want to do as far as a more frequent option. I believe the commission wants to stay where they are now as a 5-year, and I believe the assessors want to do something a little bit more frequent. I'm not intimate with the Rutherford conversations, but as I understand it, that they don't have approval yet because there was some language in their plan, separation of duties and responsibilities between DPA and Rutherford County that we didn't feel good about, sent them those edits, and that's where that process sits today.
Thank you.
Well, based on your comments, Comptroller, I'd assume that we would need to plan on having a brief special meeting at some point of this board whenever we get the 4 counties.
Well, it sounds like we have one of them that was filed after the packet of this meeting was put together.
Yes, sir. We have Hawkins.
We have another one potentially going to be approved tonight at a county commission meeting with 2 in limbo.
Correct.
I guess what my concern is about the ability of these counties to get started in earnest in their reappraisal work without having this step of approval of their reappraisal plan. What would you say about that off the cuff?
It is a concern. In a few situations past where this has occurred, we have worked with the county with what we knew to be their plan and worked with them to achieve that plan even before they have actual local approval.
All right. Well, Mr. Chairman, we may indeed, again, we might have 2 of these 4 ready to go as soon as next week. We will need to talk about potentially a special called meeting just for the purpose of approving these reappraisal plans. And moving forward from here, I will talk about potentially a letter to the assessors, the mayors, and the county commissioners from the counties that are kind of dragging along, stressing the importance of having a timely submitted and approved reappraisal plan. Thank you. But again, I renew my motion that we approve the 24 that have been submitted as submitted.
All right, so we've got a motion on the table to approve those items which are currently before us. It's been seconded by Commissioner Giorgano. Is there any further discussion? Seeing none, Mr. Pope, call the roll on the motion to approve.
Miss Betty Burchett,
Yes.
Mr. Jeff Fleming,
Yes.
Secretary Hargett,
Yes.
Commissioner Giorgino,
Yes.
Ms. Erin Merrick,
Yes.
Comptroller Mumpower,
Yes.
Treasurer Lillard.
Yes. All right, that's unanimous, and so that item is approved. All right, next go to item number 10, which is review of petitions for review as outlined in your materials. And Mr. Pope, you want to begin presentation with the first matter and any preliminary comments you have. The first matter is French Brothers Dynasty LLC
Yes.
versus Hamilton County Assessor's Office.
We have 4 petitions on the docket for today's meeting. Those are petitions that were filed, and we received the entire administrative record before in time for today's meeting. As a reminder, all these appeals were initially heard by an administrative judge who received proof from the parties and then entered a written initial decision and order on that appeal, which would otherwise become final unless one party appeals to this body. As part of this, the board members, you may you're being asked to review that decision. You can decline to exercise review entirely and essentially let that administrative judge's decision become that final decision of the agency. You can otherwise refer to the review to either myself or someone else for a recommendation. You can pick up and review the appeal today, and we have people ready to present oral argument on those appeals. You can otherwise delegate to one or more board members or otherwise adopt the decision in its entirety. You have pretty broad discretion on your action or to decline action altogether and just let that decision become final. Of our appeals, the first one on the docket was French Brothers Dynasty LLC versus Hamilton County Assessor's Office. I did not receive any requests to present oral argument on this appeal prior to today. In this appeal, and I apologize if I mispronounce anyone's name, Mr. Kushal Patel, an owner of French Brothers Dynasty, filed the appeal directly with the State Board of Equalization for tax year 2025. Chief Administrative Judge Philip Hilliard conducted a hearing on that appeal in October and then issued an initial decision and order in December. Ultimately, the judge found that the taxpayer failed to demonstrate by a preponderance of evidence that there was reasonable cause for the taxpayer not first appealing to that Hamilton County Board of Equalization, resulting in a dismissal of that appeal. That would be the first case on under this agenda item today.
Okay, on this first case, French Brothers here, I've reviewed the transcript in this case, and I've reviewed all the exhibits in the case and everything. And as Robin said, it's simply a matter of the taxpayer claims he did not get his notice in the mail as his tax notice or his reassessment or reappraisal notice in the mail. And of course, it's noted that there was a publication in the newspaper and other requirements were met. And the administrative law judge dismissed his petition as a result of that. So from that standpoint, is there any discussion by members of the board on this case? If there is none, I'll move to affirm the decision of the administrative judge and dismiss the matter.
I'll second.
All right, we have a motion and a second. Any further discussion? Seeing none, let's see. Mr. Pope, would you call the roll on the motion to approve that motion?
Ms. Betty Burchett,
Yes.
Mr. Jeff Fleming,
Yes.
Secretary Hargett,
Yes.
Commissioner Giorgino,
Yes.
Ms. Erin Merrick,
Yes.
Comptroller Mumpower,
Yes.
Treasurer Lillard.
Yes. All right, unanimous. That motion is adopted. Next item is item 2, Daniel Hemmerly versus Williamson County Assessor's Office. Mr. Pope, you want to summarize this case for us?
Yes, Mr. Daniel Hemmerly, property owner of the subject property, filed the appeal directly with the State Board of Equalization for tax year 2025. Administrative Judge Alexander Rieger conducted a jurisdictional hearing on the appeal in October and issued an initial decision order in January. The judge found Mr. Hammerly failed to meet the burden of proof to show that there was reasonable cause for failing to first file an appeal with that local county board of equalization, and then which ultimately ended up in a dismissal of his appeal. He elaborated that petitioner called after June 12th and therefore missed the opportunity to be scheduled for an appeal before the county board. Instead, petitioner filed an appeal directly with the state board on June 13th, 2025. Petitioner gave no reason as to why he did not timely call to contest his valuation so that he could have an appointment scheduled with an appeal before the local board.
Okay, on this item, item number 2 on the contested case docket, again, I've reviewed the transcript in this case and the exhibits, and Mr. Pope properly summarized the facts of the case, and accordingly, I'd move to affirm the decision of the administrative law judge.
Second.
All right, we have a motion and a second. Any discussion? Seeing none, Mr. Pope, call the roll on the motion.
Miss Betty Burchett,
Yes.
Mr. Jeff Fleming,
Yes.
Secretary Hargett,
Yes.
Commissioner Derrigano,
Yes.
Miss Erin Mary,
Yes.
Comptroller Mumpower,
Yes.
Treasurer Lillard.
Yes. All right, it's unanimous. The motion is approved with respect to item number 2, the Hemmerly case. All right, on item number 3, Donald W. Bible versus Roane County Assessor's Office. Mr. Pope, would you summarize this matter for us?
Yes, I would also note off at the start that Mr. Bible and the attorney for the Roane County Assessor's Office have requested to present oral argument. And Mr. Bible is here, and Mr. LeFew for the Roane County Assessor's Office is online. In this case, the Roane County Assessor's Office is actually petitioning to this board following the initial decision and order on this case. Mr. Donald Bible, property owner of the subject property, filed the appeal with the State Board of Equalization following an appeal to the Roane County Board of Equalization for tax year 2025. Administrative Judge Richard Murrell conducted a hearing on the appeal in October. The administrative judge issued an initial decision order in February of this year. The administrative judge ultimately found the value of the property for one parcel and the other parcel should remain as valued. $101,400 and $52,800, I believe respectively. The administrative judge also found that one of the parcels should be subclassified as residential. And the Roane County is, like I said, the Roane County Assessor's Office has petitioned this board for review.
Okay. Are there any member wish to discuss this particular matter?
Yeah, I have something, Treasurer.
All right.
If I could ask Mr. Pope, is there any action outside or any potential for action outside of this body that's pending right now on this case?
Any action? Not
Has it been filed in Chancery Court already, or?
not that I'm aware of. No.
Okay. All right. Thank you.
Mr. Chairman, if I may,
Go ahead,
if
Commissioner.
we hear from Mr. LeFew, I may have a question about the statute, but I think it'd probably be
Okay.
better directed to him.
All right. Let me follow up on the Secretary's question here. Robin, are you or the division aware of any cases out there that are potential cases before this board that could involve similar issues, like the issue of when 2 or more rental properties constitute a commercial assessment property?
Yes, we have quite a few appeals related to the similar issue regarding subclassification of property that's otherwise used for residential purposes, but maybe subclassified as commercial under the property assessment statutes that apply. There are other appeals involving similar issues, correct?
Okay. And I assume those are just working their way through the pipeline at present here.
Correct. We have, I think, offhand, I'd have to double check everything, but I know we have appeals regarding that similar issue at differing levels. We have some, I think, ones that have had a hearing and are awaiting a decision, others that are scheduled for a hearing but not yet heard. I'm trying to think if we have any. I don't recall any currently pending Chancery Court litigation on that issue. And we have some that are filed but yet to be scheduled. So we have appeals, I think, on that. Similar issues at kind of varying points in the process. Generally speaking, at the administrative level, decision on one case is not binding on any other case. It is persuasive authority at best for other cases. But when it comes to subclassification, the specifics of the specific property may be a determining factor. So certainly decision on this case does not result in is not a binding decision on the board. It is only binding on the specific parties involved in this specific proceeding that are addressed in the order. It's not otherwise going to apply to anyone else. So while we have similar issues. We've got similar issues, I think, with a lot of appeals. A decision in one does not necessarily become binding on any other appeal.
Sure. Okay. All right. Does the board wish to entertain oral argument from these, the petitioner and the respondent in this case?
Well, I have a motion.
Yeah.
Okay, and I'm good either way, but given what you just said, and I understand that whatever we decide on this case will not be binding on other cases, I do think it would be wise for us to let some other cases potentially catch up and be able to hear more of these at the same time if we decide to do that. I'm going to move that we delay consideration of this appeal and put on the docket for the next meeting.
Okay. And I guess, let me ask this question for clarification, Secretary. Are you wishing to delay it in order to combine it with some of these other issues that are coming up that are similarly situated, or?
I would not use the word necessarily combined to be
Mhm.
heard in
Mhm.
a similar timeline is what I'm thinking.
Mhm.
Because while I know they're not binding, in order to be consistent, I'd like to be as consistent as possible. I think it'd be wiser to not hear this one today and wait to hear others at the similar time.
Mhm. Okay.
But the board may also choose to decline review entirely and let that otherwise decision become final. Essentially saying no opinion on that decision.
I appreciate that being an option. That's not what I'm going to vote for.
Okay.
Thank you.
Well, and obviously, if we were to decline, for instance, in the end, we'd just be putting the matter before the Chancery Courts, what we'd be doing, letting
Assuming
the
that's what
courts decide the
assuming person
issue.
would take is
Assuming
to that
somebody
record.
takes it up to that level, that's right. So, so here we are, we have a motion. Is there a second for the motion?
I'll second it.
All right, we have a second. All right, is there further discussion of the motion? Does the board wish to hear argument from these individuals that are here today?
Chairman, I think I agree with Secretary. This is Betty Burchett.
Yes.
Sorry, of course, my phone wants to ring as soon as I take it off mute. Because if we do have multiple cases like this, I think it's something we might need to review. So I agree. We just hear them all at the same time.
Okay. In that regard, then I assume that we don't need to hear from the individuals involved here today, and we might hear from them in the future, depending on how that works out in the future here.
Yes, if the board would like to I guess, I'm trying to, sorry, my words are escaping me. If you'd like to postpone action on this and hear it again at a later time, we'll notify the parties about that and they can re-request to present oral argument at that later time if that's what the.
Certainly. Yeah, they have that right.
Yeah.
Okay. All right. So is there further discussion on Secretary Hargett's motion?
Just for clarification, Mr. Chairman,
Mhm.
Mr. Secretary, was your motion to delay consideration of this item until the August meeting?
That's my intent. Of course, if others don't catch up in that amount of time, frankly, I'm probably going to come back in here in August and kick the can a little further down the road.
So you're saying the next regularly scheduled meeting?
Yes, sir.
Past any specially called meeting?
Yes, thank you for the clarification.
Which is currently on the calendar for August.
But as you indicated earlier, there may be a need for a specially called meeting before that. My anticipation will be August.
Thank you.
That is the motion.
Okay. All right. Any further discussion? All right. Seeing none, Mr. Pope, would you call the roll on the motion?
Miss Betty Burchett,
Yes.
Mr. Jeff Fleming,
Yes.
Secretary Hargett, Commissioner Jaragano, Miss Erin Merrick,
Aye.
Comptroller Mumpower,
Yes.
Treasurer Lillard.
Yes. All right, it's unanimous. Then that motion is approved with respect to item number 3, the Bible case. All right, item number 4, which is Glenn David Sawarski, I believe it is,
Yes.
versus Sequatchie County Assessor's Office. Mr. Pope, give us the summary on this case.
Yes, and before I forget, Mr. Sawarski did request to present oral argument on this as well. Glenn David and Judy Sawarski, property owners of the subject property, filed an appeal with the State Board of Equalization following an appeal to the Sequatchie County Board of Equalization for tax year, I have it as 2024. Administrative Judge Carolyn Reed heard the matter in November of 2025. At the hearing, without objection from the assessor's office, the appeal was amended to also include tax year 2025. The judge ultimately issued an initial decision order in February of this year. The administrative judge found the taxpayers failed to meet the burden of proof to establish a more credible value than that as adopted by the Sequatchie County Board of Equalization. The administrative judge elaborated that the taxpayer failed to prove by, quote, the taxpayer failed to prove by a preponderance of the evidence that his contended value of $197,820 for the subject property is more likely than not the correct value, or that the valuation of $418,900 adopted by the local board should be reduced.
Okay. We have Mr. Sawarski who wishes to be heard on this matter. Does the board wish to entertain oral argument on this matter? I assume we do. All right, so 3 minutes, is that enough, I think, per side?
Yes, we typically do 3 minutes per presenter, and I have my notice up here. So as well, I will hold up 1 minute when he's got 1 minute remaining, and hold up time elapsed at the end of those 3 minutes. I do just want to make sure. I know we got Mr. Sawarski here. We did test his equipment earlier. I believe we can hear you, but let's if you don't mind giving us a shout before your time begins, and then introduce yourself as well.
Yeah, hello, I'm Glenn Sawarski, and I'm here with my wife, Judy Sawarski, and we're here at this meeting. I want to thank the board for taking the time to allow us to present our case in front of you.
All right, Mr. Sawarski, you're recognized. Proceed when you're ready.
All right, I'm going to make it real quick. I have probably a lot longer than I really wanted to. But when we had the appeals, all the documents were supposed to be sent in at the same time for discovery, meaning that I sent my documents to the system, that's the SOBOA, and also the county, which they refused to do. And what I'm coming back here with is under SBOA rule 0600-01-11 parentheses 4 and civil rule 1360-0401-.11 under the uniform rules of Tennessee civil procedure. And what I'm saying here directly, that would provide discovery for us to learn what the county had. It was never done that way. And by your own rules and regulation, that was to prevent any kind of ambush during these trials. And if you look up those codes, you'll find out exactly what I'm talking about. I believe that was violated and wasn't given the proper time to prepare for that case at that given time. And all I did is took what I could, local comps to compare it with. In fact, that was one of the arguments I had with Judge Reed, that when I submitted all those forms to her, she had said in open court, no time to even review them at that time before the hearing. And my complaint came back in as I was trying to be really fair and reasonable in my directions of that. And I try to show her some of the houses that were in my area. And in fact, the one I presented in my appeal I sent to you is almost exact similar house, but I was wrong on the value on that. And you can check the record on there, what I submitted to this hearing, that brought it up considerably, which I find within a reasonable figure and valuation. As you probably know, in Sequatchie County, the values of the houses have been decreasing at an alarming rate. I mean, from the point of selling, there are a bunch of homes that are outside our area that have been on the market for almost 2 years and they've never sold. Now, the only house that was close to me was on October 17th, 25, just about 2 weeks before I come to the hearing. And that's the one I submitted for a reconsideration for the value of the house.
Okay, does that conclude your remarks, Mr. Sawarski?
Yes, sir.
All right. Let me ask you one question, Mr. Sawarski. You had I've listened to the entire transcript in this case, and the judge gave you an opportunity during that to ask any questions of the assessor that you wanted to ask. And you asked a number of questions of him during the time. You ought to interchange back and forth a good bit. I mean, did you not have an opportunity to get information at that particular point?
What I'm saying, sir, is they should have submitted that or at least weeks or months before. I could have went into the record and reviewed what they had or what they were going to present, not on the day that they showed. In fact, when they showed, they were almost an hour and a half late for the hearing. And then they'd never submitted any kind of discovery through the system, which I could have reviewed and probably would have came up with a better evidential ruling or reasoning about the value of the houses. And it didn't give me, and it didn't allow me that kind of time to prepare. It was like on the spot.
Let me ask you one other question. During that interchange, during the hearing that Judge Reed, you asked, it was pointed out at one point that the assessor used what they call a mass appraisal technique, which is a recognized technique by assessors. And so, you know, there was an opportunity to discuss that at that particular point and gain any information or knowledge that you wanted to about the assessor's use of that technique, was there not?
And to be honest with you, I don't remember that being either advised or even suggested at that time. All I know that the county had raised the taxes almost 66.5% over the house on the previous valuation of that house.
Right. Okay. Well, that was discussed during that hearing. So, is there any other board member that has any questions or anything of Mr. Sawarski at this point? Is anyone here from Sequatchie County?
One quick question, if I can. Well, thank you very much for being with us today. Were you required or did you submit any of your evidence prior to your initial hearing?
Yes, I did. I did it 2 months in advance.
Were you required to do that or did you voluntarily do that?
Well, they told me if I didn't do that, nothing would be considered. So if I even brought it into the hearing that day, it would never be considered as any evidence.
Got you. Thank you.
Okay, does anyone else have a question or anything for Mr. Sawarski here? Is anybody here from Sequatchie County wishes to be heard?
I did not receive a request from the assessor to be heard or to present oral argument on this. I have the assessor as James Condra and with his assistant Kathleen Bravo. Let me see. I don't believe they are in the assessor. I do not see them in the attendees for the meeting.
Okay. You know, let me make a few comments about this. This is a rather voluminous record in this case and everything. As I said, I sat down and went through the entire thing from soup to nuts and looked at it. And you know, I believe that Mr. Sawarski has had due process given to him in this particular case from a number of different standpoints. I think he did as good a job as he could as a pro se person in this hearing. And so did the assessor, for that matter. He represented himself and his office in the matter. This case involves Mr. Sawarski submitted a lot of material off of the internet about what he claimed were comparable values that should have been used by the assessor's office. Of course, these things were, as the judge notes in her opinion, some of them were not dated and didn't have appropriate context around them, and also did not indicate whether an actual sale had occurred or whether it was just an asking price or what it was you were dealing with at that particular point. Also, a second point in this particular case was an area in the basement of the house, the lower level, that was somewhat unfinished. It was finished to some degree in the sense that it obviously, from the pictures, had been finished out with electrical and HVAC ductwork and other things like that, and windows and everything else. But that was a point of contention about whether those square feet would be included in the assessor's calculations with regard to the matter. And that was important. Excuse me. Sorry about that. That was an important consideration in the matter because utilizing the assessor's techniques, if you include that area in it, then it would yield a value that's much higher than what Mr. Sawarski claims it has in this particular case and all. And so, you know, I think this is a case where obviously, as I said, the petitioner below, Mr. Sawarski, has had an opportunity for substantial due process to be had here and had an opportunity to be heard and to submit evidence and all, and an independent trier of the fact the administrative law judge has reviewed it and entered an opinion accordingly. So I think in light of all of those factors, I think we should affirm the decision of the administrative law judge, and I so move. All right, we have a second on the motion. Is there any further discussion on the motion? All right, seeing none, Mr. Pope, call the roll on the motion.
Miss Betty Burchett,
Yes.
Mr. Jeff Fleming,
Yes.
Secretary Hargett, Commissioner Giorgino, Miss Erin Merrick,
Yes.
Comptroller Mumpower.
Yes.
Treasurer Lillard.
Yes. All right, the item's unanimous, and so that action on the Swirsky case is confirmed. All right, thank you, Mr. Swirsky, for being here today. All right, is there anything further to come before the board today?
The only thing I think I would be remiss to say is we would be here without the wonderful work of Miss Connie Sands. And if you could help me wish her a happy birthday tomorrow. But other than that,
Okay.
no.
Okay. All right, anything further?
No.
All right, I'll move to adjourn then. Is there a second?
Second.
All right, Mr. Pope, call the roll on the motion to adjourn.
Miss Betty Burchett,
Yes.
Mr. Jeff Fleming,
Yes.
Secretary Hargett. Commissioner Giorgino,
Yes.
Miss Erin Merrick,
Yes.
Comptroller Mumpower.
Yes.
Treasurer Lillard.
Yes.
You are adjourned.
All right, we're adjourned. Thank you.